moving to our next session. Next session is brand and protection, trademark protection, trends, challenges, and dispute resolution. So I would like to invite Kamal Sharma, Director and Assistant General Counsel, Procter and Gamble, UAE. Rajesh Jagasia, Managing Partner, Right Just IS Justice. I'm so sorry, sir. Lawyers and Consultants LLP UAE. Ms. Sadeh, Managing Partner, Hangam Legal Services Iran. Mona Adel, Deputy Manager, Trademark, United Trademark and Patent Services UAE. Please welcome them on stage.
Good morning, everybody. I hope you are all live and active to enjoy this session, which will go back from when the brand protection started. I believe in UAE it was 1996. Since then, I've been here. But we all will be speaking individually about our case laws or experiences or the academic way of dealing with it, which we have already heard many places, of how we do the brand protection or how we do the trademark registration for our own company or client benefits. So we'll start with Mr. Sadek. He's a lawyer from Tehran, Iran, and he'll be speaking about his topic.
Thank you. Hello, everyone. I'm still thinking about the metaverse topic. It was amazing, I think, especially the concept of the Airbus, the twin engines. Okay, my name is Sadek Shamshiri. I'm Iranian IP lawyer with 15 years experience in litigation. I'm co-founder of Hangam Intellectual Property Law in Iran. Today, I would like to discuss some of the unique challenges trademark protection will face in countries under sanctions, a topic that has become increasingly relevant in the global IV landscape today. For 4 decades, Iran proudly held the title of the largest, richest, most sanctioned country in the world. But the title has now passed to Russia, and we Iranians must gracefully step down. In theory, IP assets are exempt from US sanctions. However, the practical realities of protecting trademarks in a sanctioned country reveal a different story. Foreign companies can register their trademarks directly or through international mechanisms, such as Madrid system in the sanctioned countries like Iran or Russia. However, trademark protection goes beyond the registration. It actually depends on the active use, enforcement, and commercial presence, all of which are deeply affected by sanctions. According to the Iranian law, as in many jurisdictions, registered trademarks must be genuinely used within 3 years of the registration date. Failure to use a trademark makes it vulnerable to cancellation for non-use. Due to economic sanctions, many international companies have withdrawn from the Iranian or Russian market, often keeping their trademark registration on file, but not actively using them. This creates opening for local or international competitors to target these inactive trademarks. As per the latest Iranian decision made by the courts, decisions by Iranian courts, sanctions are not considered a valid defense for non-use. It means you cannot say that due to these sanctions, our clients could not use their trademark in Iran. Consequently, foreign trademark owners risk losing their trademarks in Iran due to non-use. Historically, but the canceling a trademark is not that easy for non-use in Iran. Historically, filing non-use cancellation in Iran against foreign right holders was tough and difficult. Courts were previously required to deliver legal documents through the Iranian embassy to the defendant. Normally, we should, as a claimant, we should translate the documents, we should deliver to the Foreign Affairs, and the Foreign Affairs will send the documents to the embassy, and the embassy should serve the documents to the defendant. But normally, the process is very slow, and which result in the renew of the hearing sessions or the dismissal of the case. So it was very difficult until the recent legislation in Iran. In 2024, with the introduction of the Protection of Industrial Property Law, the landscape has changed. Under the new law, the latest address provided to registration authority is considered the official address for judicial proceedings. It means, in most cases, this address belongs to the foreign company's local attorney. This change has simplified the legal process. The address of the foreign companies is the address the local attorney provides to the trademark office. So, by allowing local service of the documents, courts can now engage foreign companies in legal actions more fast and efficiently. In my experience, over the past 6 months, the trend of non-use cancellation actions has gained considerable traction as a legal approach in Iran. During last 6 months, I received 3 court notices for a non-use cancellation served directly to me. The cases were against my clients, which they registered the trademarks in Iran during last 5 years. Now, what are my suggestions to you and your clients in this matter? I think maintaining consistent communication with your local partner is now critical because your relation with them will not finish after registration. Court notices will reach you faster than before, and your client should be ready to respond to the courts. Otherwise, it will result in cancellation of the trademark they have. Brand owners should review their commercial presence and trademark use strategies in sanctioned countries like Iran or Russia. Even subtle use, such as a small-scale licensing or indirect, limited distribution of the product in the country, can help defend your client. I recommend to your client to keep detailed records of how their trademarks is being used in the countries, especially in Iran and Russia. In Iran and Russia, they should have a record of the marketing materials, export, import documents, advertisement, products, labels. All of these documents can help your clients to provide sufficient evidence to defend their case, to prevent cancellation of their trademarks. Please ensure that your local representatives are experienced in IP matters and they will remain accessible to you. As the legal landscape evolves under new rules in Iran, being proactive is the key to protecting your brand. Thank you. If you have any questions, I will be in the panel and I can answer.
Our next speaker is Mona Adil. She's from United Trademark, UAE.
Yes, good morning all. Happy to see you today. Just 1 minute. So this is Mona Adil. I'm from United Trademark and Patent Services. I'm the Deputy Manager and Legal Consultant. So our session topic today will be about the brand and trademark protection trends and challenges. So I will speak about some trends and challenges we are facing in the GCC region, not only UAE. So this is a brief about our firm. Our regional office is in Dubai. Our head office is in Pakistan. We have 16 offices in the MENA region and South Asian countries. So 2 of the trends I will speak about today. The first one will be about Madrid Protocol, because it's now like 4 of the GCC countries are member to Madrid. And the other part of my presentation will be about the AI and the digital transformation we are having in the GCC countries, including UAE and Saudi Arabia. So to be able to speak about the Madrid, first we need to briefly describe the way of protecting the mark. It should be either national mark, which means filing the trademark in each country, like through the trademark office or the ministry. The other way is the regional route, which means like in some countries as the EU or the ARIBU or OABI for some African countries, you will file an application. It will cover regionally some jurisdictions. And the third route is the international route through the Madrid Protocol or Madrid system through the WIPO. So recently we have Qatar joined in 2024 in August, and UAE joined 2 years ago. Oman and Bahrain are already joined like in 2005, 2007. So out of the 6 GCC countries, only Saudi Arabia and Kuwait are not yet members to Madrid Protocol, but 4 of them already joined. And I forgot to, sorry. So this is the national route, regional route, international route. And this is the dates where the 4 GCC countries joined Madrid, and Kuwait and Saudi Arabia are not yet, but Saudi Arabia is expected to join soon. So this is some statistics about the number of international marks designated to the GCC countries. So in Qatar, which joined most recently in August 2024, we can find that 1,299 international applications are designated to Qatar. For UAE, it's almost 2 years and 1 month. We can found 23,000, almost 24,000. And for Oman and Bahrain, they are members since long time, so the statistics are higher. In the GCC, after the joining of 4 countries in Madrid system, we are facing some challenges. First of all, If the client want to cover the GCC region, Saudi and Kuwait cannot be designated yet because they are not members. And also we can find that the national way is more quicker. So for example, if a client has international mark and designates UAE, it will take 18 months for the examination. But if we just file through the national route, it will take 4 to 5 months to get the registration certificate. So it's way more quicker. And also we can find that some the clients prefer Madrid because they will not require a legalized POE. But then when they file it, the mark through Madrid system, and in case they receive any provisional refusal, we will see that a local attorney in UAE shall be appointed, and a legalized power of attorney shall be submitted in 30 days, which is a very tight deadline. So what they were escaping from in the initial stage while filing the mark, they will face it in case any office action is issued. Also, there is a central attack. Sometimes it happens. So in the office of origin, if it is UAE or Qatar or Bahrain or Oman, and the client designate other countries, but the basic application is rejected, it will affect all the other designations, and this is what we call central attack. Some also of the challenges, like in UAE, we can record the trademark before the customs authority. So with the certificate, we can go to the 6 Emirates, to the custom authority, and have the trademark registered before the customs, so they can seize any suspected counterfeit shipment coming. But there is no yet any rules for the international mark. Can we do this with the statement of grant, for example? So the regulations are still not clear about it. And sometimes when we take enforcement action in case of any infringement, the authorities will require translation or obtaining certified statement of grant. So the certificate won't be ready to take immediate actions. And there are some pitfalls in the GCC region when we file through Madrid. For example, recently we are receiving many provisional refusals, international clients designate UAE and in class 33, for example, and they paid the fees. Then they will receive provisional refusal that class 33 is not in the UAE. So, for example, we don't have class 33 is related to alcohol. So the international clients will go through Madrid and pay the fees, and then after 18 months, they will receive a rejection that this class is not available in UAE. So it's just a waste of money and time. So these are some challenges we are facing for the Madrid system. Okay, now I will ask a question. Do you think there is any regional system which covers all the 6 GCC countries, for the trademark? If I want to file a trademark in the GCC countries, do you think there is any regional organization we can go and file and it will cover the 6 GCC countries? Any of you know? Okay. So yes, the answer is no. Although they are the 6 countries are the GCC, and they are all following same unified trademark law except UAE. So Qatar, Bahrain, Oman, Saudi Arabia, they are all following the same law except UAE. But we don't have any regional organization which we can go file the trademark and it will protect all the GCC. No, we need to file in each country separately. So the second topic the trending topic we will talk about is the AI. So we can recently witness that AI has been used in the GCC region as well. So we are using it in the trademark searches and to make sure that if we want to register a trademark, we can do a search to make sure that there is no existing prior trademark. We can use the AI also for monitoring purposes, to make sure that our mark or the client mark is not being used by any third party. And sometimes we are using the AI in dispute resolution. So we put the precedents, and then they can analyze it and suggest or help the decision maker for the decision. Recently, we can find that like the EU and the USPTO in US, UE started also to adopt the AI in its system. So number one, they are doing now digital transformation. Everything is through the online portal and even the searches. And this had made significant increase in the filing, and it encouraged the companies to file more trademarks. And we can see that also the Saudi Arabia followed UE. So recently, last year, they made the competent authority, which is the SAIP. Now, before we cannot access anything for Saudi Arabia online, but now they have uploaded many trademarks. We can do some searches on their portal, so anyone can access from anywhere. And this also helped to increase the businesses and the trademarks filing percentage. So, for example, in Saudi Arabia, after this portal, we can see that last year, the number of national filings for trademarks has increased 27% if we compare to the same time in 2023. And we can see that from USA, it's 16%, China 13%, UE 10%, Japan 9%. So these are the top countries which file in the Saudi Arabia. And after especially the AI adoption and the online system and digital transformation. Okay, now I will ask a question. Can we use the AI in creation of our trademark if a company want to make or create a new trademark? Can just we go right on ChatGPT or any other platform to suggest to us what we can file? This would be hard because there are huge number of trademarks worldwide. So most probably if we use the AI to create a trademark, it will conflict with other existing trademark. So what some companies are doing, they are having their existing trademark, for example, like Alibaba, but they are using the AI to add additional element to it, but not the main creation of the trademark. We are just add additional element, for example, like Alibaba Cloud. So the registrability chances in this option is better than creation of a trademark because like it will mainly depend that Alibaba is, for example, registered. So adding an element will not affect the registration as when I mainly depend on the AI to create a new trademark. And we have a very famous trademark case. It is for a Hawaii company. So in 2017, the Hawaii company, they launched a trademark created by the AI. Its name is Hi AI. And then they developed and they complete the launching. And then they found that another company in China filed already application for Hi AI in the same class, class 9, like same class related to the goods of a Hawaii company. And then it obtained registration. So when now Hawaii wanted to register its trademark, it filed its application in November 2017, just after 2 months. It got rejected because there is the Chinese Shanghai company already applied and registered for it in class 9. But Hawaii created this mark Hi AI through the AI. So this was gone to the court, and then it was decided that the Hi AI trademark will be invalid only for some goods in class 9, but it will be legal in other goods in class 9. So we can find that the same mark, Hi AI, is registered in China for 2 different companies. So this is one of the consequences, like it's not good to use the AI in the creation of new trademarks. So this is the details of the case. Now we will speak about, can AI help or have any effect in trademark infringement? The answer is yes, as I already explained this high I case. Also, sometimes, like I will give other example, I will ask the AI to create a brand name for me for selling film. So maybe it will suggest Codeb, which is similar to codec. So if I just follow the AI suggestion and I go with Codeb, then I will make trademark infringement to codec. So we cannot just rely on the AI on everything, especially when we are deciding which brand name we will use for our business. Other thing which is related to trademark infringement, sometimes, some companies are using the chat boxes to reply to the customers. So sometimes something called hallucinations happened, like for example, it will give fake advertisement. Maybe if I'm selling vitamin, it will say automatically it's related to ministry, it's affiliated to the ministry, so it will give wrong details, and this will also make some legal consequences to the company if we mainly rely on the AI. There is one case study which is so popular for this example. It was from Cosmetic Warriors Limited. You know, they are the owner of the trademark Lush. I'm sure the females know it very well. So it was against Amazon. So what happened, like Amazon, there was a Google advertisement by using the word Lush. But when you open the products, it's not related to Lush or the Cosmetic Warriors. So it's related to the fake advertisements. So this case went to the High Court, and Amazon was held infringed the Lush trademark through this Google-sponsored advertisement. So that's an example that we cannot rely on AI on everything. Now I will tell you about some sources which any of you, if you are dealing with trademarks, you can use it, and it's free online. It is provided by the WIPO. So the first tool is the Global Goods and Services. For example, if you are SME or startup and you need guidance, how you can file your trademark, on which class, so you can just access the WIPO and select the global goods and just write a word. It will guide you to which class, because you know there are 45 classes. We are receiving many inquiries. I need to file a trademark, which class, which maybe it's related my services or goods to more than one class. So this is very effective tool, and it has been used by many authorities, including the Australia, EU, US. So, and also it's free for public, so we can use it, and examiners are using it as well. There is another tool which is mainly through AI. It's also provided through the WIPO. It's WIPO Translate, and they are mainly using it for translating of patents. And there is WIPO Speech. It is like shifting what you are saying to a text. So sometimes it's helping, especially on the conferences. And image similarity search. So for example, if my trademark has a figurative element or image, and I want to make a search, like, does it like similar to any other mark in the market? So in the GCC, many countries, we cannot make a device search before the ministry. So if we want to make a search, we can only give the ministry or the trademark office the word, and then they will make the search or conduct it through the word, but they cannot do it by image. So if a client has an image, they can use this WIPO one to make sure like at somehow no one has a similar image related to this. And there is also Vienna classification assistance. It also helped the companies to see which Vienna class they are related to, if they have any figurative element in their trademark. And the last one, it's not related to the trademarks, but it's very useful in case some of you are handling the patent side. It's called automatic patent classification. So it's very trending and many companies are using it. So these are the tools if you want to take a photo. And I finished my presentation. I hope it was useful for you. Thank you so much. If you have any questions, I will be here. Thank you.
Hi everyone, I'm Kamal Sharma, Director and Assistant General Counsel at Procter & Gamble. Well, honestly, I was discussing it more to be a panel discussion, so I didn't prepare any presentation. Apologies for that. But I will just give you a bit of perspective from an FMCG company, being from an FMCG company. However, I would like to highlight that although I'm going to touch upon more FMCG products or FMCG industry, but there's no industry which is not impacted by counterfeiting or looker feeds or lookalikes as we talk about, or infringement of IP, so to say. See, one thing we have to really understand that counterfeiting is a consumer fraud, plain and simple. Protecting consumers against counterfeits is consistent with P&G's purpose to touch and improve the lives of our consumers around the world. Our products are used by billions of consumers as a part of their daily routines. They brush their teeth with our toothpaste, they use the toothbrush of our company, they wash their hair with the shampoo. And because of this, at P&G, we take counterfeiting very seriously. Counterfeiting of consumer products, as I said, is consumer fraud, plain and simple. Consumers unknowingly purchase counterfeit products and often paying the price of a genuine product. I mean, as a audience here, I would like to ask you, would any one of you use a toothpaste, even if it is given for free, if you know it's a counterfeit? Or use a shampoo, if you know it's a counterfeit, even given for free? So the point is that the consumers are defrauded day in and out by making them believe that these products are genuine. Often they get carried away by the discounts, etc., offered by some discounters. Having said that, nobody, as you would all agree, nobody would buy these products knowingly that these are counterfeits. And even going out of the industry, would you buy a brake shoe for your vehicle or a brake pad knowing it's a counterfeit and it can fail anytime? I really don't think so. And therefore, there is a lot more importance and attention which needs to be given to IP crimes, to be treated them as consumer frauds as well. I'll give you an example of India. While there are provisions, definitely there are provisions in the law to deal with counterfeits under the Trademarks Act, but they're not treated at the same level as a fraud. This gives the confidence amongst the counterfeiters, or I would say illicit traders or organized crime sector, to deal in counterfeits freely. If an enforcement action is conducted, usually the criminals are given a bail immediately, although it's a non-cognizable offense in India, but still. And that differs jurisdiction to jurisdiction. Now, even if we talk about overall regional landscape, in most of the emerging markets, it is the same scenario. Counterfeiters, the provisions which provide the penalty, etc., are not deterrent enough in any of the, I would say, emerging markets in today's time. Well, I would also touch upon the changing trends. So See, there has been evolution of how counterfeiters operate, etc. Traditionally, and if I talk about 5 years, 10 years back, it was mostly centric on manufacturing in certain jurisdictions and then supplied globally. Today, that trend has changed, and especially post-COVID, what we have seen in the market. Today, we see there is more and more local assembly or local manufacturing of counterfeits, which is primarily on account of cheaper availability of manufacturing equipments. Uh, but then what are the challenges? Challenges are if you conduct an enforcement action, in most countries, then not the manufacturing machinery would not be seized, thus giving the counterfeiters an opportunity to move the machinery somewhere else and start the manufacturing again. Uh, Also, we have seen a shift of counterfeiters to play around between pure play counterfeits, which are the exact replicas, and lookalikes, or what we call in PNG language as looker-feeds. They know that in certain jurisdictions, it's difficult to do a criminal enforcement in case of looker-feeds. And they always keep as a backup, lookalikes, just to say that they have their own private label, so to say, which definitely complicates any criminal enforcement against them. Uh, Other than that, there are certain things which are definitely working, which is collaboration with the law enforcement, training the law enforcement, etc. And we have seen great success of the same. And I'll take an example of Saudi, where we have been coordinating with SAIP extensively. And we have seen some success in terms of doing the enforcement against counterfeiters. But one of the challenges which we see, and that is all across, I would say, in most of the markets in the region, is that in very rare cases, there are suo motu actions by the law enforcement. And as I said, these are consumer fraud. The counterfeiters do not only hamper or impact the economy because they do not pay taxes, etc., but they are a consistent threat to the wellness and well-being of the consumers as well. And therefore, there is definitely a need to look at the opportunity of higher collaboration between the different law enforcement agencies as well as the stakeholders. I think with that, I will rest it. I mean, there are a lot of things I can talk about, but I think for the sake of time, I will stop over here. But I'm here in case you have any questions. Please feel free to ask. Thank you.
Again, good morning. I'm the last but not the least, because we saw sanction country, we saw procedures of registration, we saw a company getting involved. So now I'm getting involved in actual enforcements which I have been doing worldwide. We had clients from America, we had clients from Europe, we had clients from Southeast Asia, Japan, Korea. We did a lot of seizures. My name is Rajesh Jagasia. My company name is Right Justice. So what I believe always is do the justice to the client. How to do the justice? People go for enforcement. I've seen in UAE, the companies are doing the seizures for small amounts of quantity which will not hit the infringer. And what to take the compensation for that? You have to go to the court, we pay, the clients pay us, so that it becomes aware to all the others that don't touch this product. So ultimate slogan is don't touch this product. And how is that possible? This is possible only when you have a quantity seizure hitting the manufacturer or the trader in such a way that he does not think of doing the infringement again of that product. So I just discussed two cases, which were the biggest cases which I handled. And that one was, we had two offices in China. So a client came to us and said that we have a product which is being infringed and sold at a very high profit because the quality was very good. We don't know from where it is coming, but we think as we had already handled the cases in UAE, they were told us to find out where it is coming from and whether we could take good action. Because stopping in China any infringement, it was not easy. As Mr. Kamal also mentioned, what they would do is we seize the product and they would take the machinery and go to other place and start in another province, because there are many provinces in China. So we had office in Guangzhou and EU, and we attended some exhibitions and shows, and we ultimately got to the factory. Now, how to trap the factory? How do we know where they are located? Because they are in Guangzhou, and their factory may be somewhere in Shanghai or Beijing or Qingdao or somewhere. So we had, being experienced, I have lived in Southeast Asia for 7 years. I've lived in South Korea for 5 years and Hong Kong for 2 years. Having the experience of dealing with many, many traders, I got involved myself in how to get to this factory. So we told the company, we are placing, we have a client who wants interested to come and see the factory and who wants to maybe buy a product from you. Which product we don't know, so you can help us in, because they are interested in that particular industry for which we were appointed. So we went ahead and we found that it is in Northeast China. In Northeast China, they did not take us to the factory, but we told them we can bring the buyer here and you can make a negotiation for how the trade is to be done. Convinced, they placed the order, and we call it trap order. We call it trap order. But the order quantity was so huge, it was 5 million euro worth of goods in European market. 5 million euro. So means costing could be 1 million. Or maybe half a million. Half a million or 1 million is a big amount in China. And so we got the factory, we got the goods, and the factory and the machinery closed down. They could not operate again. They could not move to another place because it was a very big amount of loss for them. So our concept of working is, there is trademark, there is trademark registration, there is patent registration, but when there is an infringement, what do we do? What do we do to protect our client? We are lawyers. What do? We have to go, we have to get them justice. They are big companies, or whatever company it is, they invest a lot of money in developing a product. And then they do the registration. They come to us for registration. But after registration, what happens? When there is an infringement, what happens? They come to us again. So what action do we take? What action we take so that they are benefited? Again, my company name is Right Justice. Then we had one case, small case of parallel goods. Even parallel goods hit everybody's market. A distributor who invests money, who signs the agency agreement with the company, also has problem. Now we had a product company coming to us and saying, somebody is making our item in a different size, but it is original. We have checked it. We have checked the laboratory. We have seen everything. We don't know from where it is coming. And it was in huge quantity. Because if this is a quantity, this is the item, you reduce the size, so which will sell first? It will sell, this will sell. The smaller size will sell first. So what happens to the bigger size? It will remain in the stock of the distributor. This also hits the distributor and ultimately the company behind. So we went into that and we found out that the original company somewhere in Southeast Asia was manufacturing different size for their different market, and that was being produced more quantity and supplied to this market where I am located. So infringement is a very, for me it is that you protect the rights of the person who develop an item and they do the registration for the benefit of the consumers. The consumers, they are defrauded, they don't know what they're buying. Many years back, Levi's company came on TV and showed which is fake Levi's and genuine Levi's, so that the consumer decides what they want to buy. Because when they used to go to the shop, people used to be scared to pick up a Levi's jean, not knowing whether it is original or duplicate, or it's a counterfeit. So they went for awareness to the consumers that you buy this or you buy this, it's up to you. But that was really successful for the company. Second case we had also is a very big case. When I started my own practice, I was associated with some guys. And when we started in 1999, we had a company approaching us because all of my associates at that time left the country. And they told us that we have a product which is being sold on the retail counter of pharmacy companies. It was not a pharmaceutical item. It was something else. I cannot name the company, name the product, nothing I can say, because it's always privileged information. They came to us and said this item is duplicated and it is being sold on the counters of retail shops at the airports also. So you can imagine the level of counterfeiting. You can imagine the amount of, it was 99.9999% counterfeit. So when they left from UAE, I was given in charge, the company told us, please do something about it. And they gave us 7 leads. They said these 7 companies, I think, are involved in the counterfeiting. So we checked it, or we went to the 7 locations, and ultimately we found it belonged to one owner. So that one owner was operating from different 7 locations in UAE. So we got to know who the owner is, and I approached him as I was new very much in the trademark infringements. I approached him, I said, let's do this, that we need this for you, for our client from South Africa. From South Africa, a client came. We make him flew down from Joburg to Dubai. And he sat in the meeting. And after the meeting, when their deal was finalized, he sat with me. I said, I don't want, because the price quoted was the original price. It was for the original, it was shown as the original product. So I said, I don't want, my client doesn't want this. And we are not interested in this. We want something which is cheaper and selling fast. Because South Africa is a different market. There only 15% are rich class and balance are all Africans. So we don't know what will sell, how much price it will sell. We need a cheaper item for the country. So they told us, okay. And I went for a dinner with him in Hyatt Revolving Restaurant. And when we sat there, I told him, if you don't trust, then don't do it. What I did was, I just convinced him. And he told me the whole story. The story went like this. The product, which was the packaging, the main packaging, it had 2 packaging. One packaging was done in Europe, the other packaging was done in China, and the third, the product, was done in Europe. All these 3 items were assembled and they were got and distributed to all the main retail shops. What was the difference? Because some items can be counterfeited easily if you know the formula. Like, example is Panadol. Panadol has certain content of paracetamol. Okay, if you reduce the paracetamol, it becomes an original product with the paracetamol quantity being less. And so when Panadol sells in the African market, they have to buy 3 Panadols instead of 1. So there are many ways of counterfeiting. It is not only that it will be look-alike or it will be counterfeit. There are many ways to do it. So these guys, they assembled the whole product. The difference was one, there was a logo in the original product below the first packaging, which logo did not appear in the counterfeit and which was not noticed by the original company anywhere in the world. So my company name is Right Justice. We do justice to a client. because they invest a lot of money for our safety, for our health, be it any item, be it clothing, be it pharmaceutical, be it cosmetic. We have handled everything in our career of 30 years, and we welcome all of you if you have any query in UAE market. And now we have started operating in Mumbai, India, and we have already been in China. Thank you so much.
So do we have any questions from audience to the panel members? No questions? I was not able to see, sorry.
Hi, my question goes to Mana. You mentioned about the unified trademark for the GCC region. I have two questions. First, what is, you said that UAE has a different law. What are the differences? And second, what prevents them from having a unified system?
Yes, hello. So the GCC countries, they are all having GCC trademark unified law. But for UAE, this is the only one country out of the 6 which is applying its own law. There was an old law. Then recently in 2021, they issued a federal new trademark law. There are many similarities between the federal trademark law and between the GCC unified law, but it is the government approach to have its own federal law. So we can see that Oman, Qatar, Bahrain, Saudi, they are all having the same law and executive regulations except UAE. But in the similarities, they are mostly similar. So as to the process and examination, and they also in the federal law, they now include the smell trademarks. So they are almost similar, but they are not following the GCC unified law.
Thank you.
Thank you.
Any more questions? No questions? So thank you so much, all the panel members and Mr. Rajesh. So now I would like to request Rajesh to please honor the remaining panel members. Here is for Kamal Sharma. This is for Sade. This is for Mona. And this is for you. Yeah, sure.
Mic. This is a big clap.
Thank you. All the panel members, please join for the group photo. Thank you so much. Thank you. Thank you, Mona. Thank you so much.